Very good. If everybody's ready to go, I'm going to call the case. Um, this is the matter of Kemeter v. Regents of University of Michigan in the Court of Claims, docket number 22-94. We're here on defendant's motion for summary disposition. So, Mr. Tuckle, it's your motion. You can proceed.
Thank you, Your Honor. Good morning. Daniel Tuckle appearing on behalf of Defendant University of Michigan. Um, this is a single count complaint alleging breach of contract for wrongful denial of long-term disability benefits. And I mentioned in my motion papers, but I want to mention again that as a preliminary matter, plaintiff has never filed a witness list as required by the court's scheduling order. That omission was pointed out. Still, a list was not filed, and even after it was raised in the motion for summary disposition, it was not filed and has never to this date been filed. So my first argument is that if plaintiff is unable to call any witnesses, then she won't be able to meet her burden of proving the existence of a contract breach and damages. And on that basis alone, defendant is entitled to summary disposition. But turning to the merits of the case, in reviewing a denial of long-term disability benefits, the standard of review is whether the claim administrator's denial was arbitrary and capricious. There have been numerous cases that have held that when discretion to determine eligibility is clearly reserved to the claim administrator, the arbitrary and capricious standard is what applies. And in this
What
case,
Michigan case has held that that's the case in a non-ERISA case?
well, there are several cases that have decided that under the very LTD plan at issue here. I've cited the Gonzalez case, the
Right.
Prof case, and the why is the name escaping me now? The
Talking
Clements
about Clementi?
Clements, I believe,
Clement.
Clements, and that was a Michigan Court of Appeals case. The
Yeah,
other
but that's
two,
not published, right? And they denied
it,
publication.
it is not published, but the only basis on which this is not an ERISA case is simply because as a public entity, the university is excluded from ERISA. But the standards are the same, the issues are the
Well,
same.
I'm sorry to interrupt you, but here's where I'm hung up because I just read all the cases again, which is, Firestone and Anderson go into a lot of depth about why we import trust principles to ERISA. And that's the basis for the arbitrary and capricious standard. I read Clemens, and I agree with you that it says that uh, that panel applied the arbitrary and capricious, but no one seems to have explained why it should be imported from ERISA into non-ERISA. Um, so if there's any case, either in our courts, I mean, I know the two court of claims decisions, either in our Michigan appellate courts or in federal court, are there any cases that have explicitly said in a non-ERISA case this is the standard?
I don't think that there are cases that say it in that way. There are simply cases that have applied that standard in a non-ERISA case, including the three I've cited under this very plan. Um,
Right.
and I think the reasoning of the other cases all makes sense. There's simply an exclusion under ERISA for a public entity, but there's no indication that a different standard should apply because of that.
Well, but if it's a common law action, I mean, whatever the reason that ERISA doesn't apply, whether it's technical or a big reason, I don't know. We're aren't we still dealing with just a contract case?
Well, it is a contract case. It's certainly been pled as a contract case, and I don't dispute that it is a contract case. It's just a question of how that contract is interpreted and how a denial of benefits under that contract is applied on review. And if you look at it from the other way, I think you can see a policy reason why the arbitrary and capricious standard should still apply. Otherwise, it's putting essentially the court in the position of making medical judgments as to whether or not the claimant is actually medically disabled, which is
Uh-huh.
not a role that I think is appropriate for the court to have, or probably the court wants to have. It certainly is a cleaner type of review to decide whether there was sufficient evidence on which the claim administrator's decision was based.
Okay.
Otherwise, we're really in a quandary about how these matters are going to be reviewed and you're putting the court in the position of second guessing medical providers of medical opinions.
Okay. All
Um,
right. Go ahead.
and frankly, I think that for purposes of today's motion, the standard of review is obviously a critical issue, because I think if the
Agree.
court agrees with the three cases I've cited, all applying that standard, that is the standard to apply, it's a much easier decision to make as to whether or not the denial was arbitrary and capricious.
Well,
Um,
I'm going
and
to stop you one more time because I'm going
yes,
to ask Mr. June if he agrees that under the arbitrary and capricious standard, there's no question of fact and his client loses. And I guess I have the opposite question for you, which is if we were to conclude that de novo review applies, do you agree that there's a question of fact?
you want me to go first?
Yes, I'll wait. I'll get him when he argues.
um, I think if the question simply boils down to, was she disabled? Did she meet the definition of disability? And we have different opinions on there. Then I think there's certainly a good argument to be made that there's an issue of fact. I don't think that's right. And by the way, I would point out, when you asked if there are cases clearly indicating that this applies even in the non-ERISA case, if you look at the Giles case, which is the
Yeah,
case that plaintiff relies upon, that was the one case that was cited in which the arbitrary and capricious standard was not applied. And I think the reason that it was not applied demonstrates why that case is not applicable here, because the argument was different. It was an earlier, different version of the LTD plan. And
I
the only
remember.
argument there was that discretion was preserved because the language said that you had to submit satisfactory evidence. And that's
No,
not
I get
what's
that.
relied on
I,
here.
I get
But
that. That's different.
in that case, Giles Court, while they said the language you cited now isn't enough to preserve discretion, they went on to say, but if you do clearly preserve discretion, then the arbitrary and capricious standard still applies. So
Right.
I think that can be interpreted as a case saying, yes, even in the non-ERISA context, if discretion is clearly preserved, as I don't think anyone can dispute it was in this case, then the arbitrary and capricious standard does apply. And turning to the evidence here, if the court applies the arbitrary and capricious standard, there's ample evidence that the decision to deny benefits here was not arbitrary and capricious. There were two different independent medical exams performed by two different board-certified medical doctors in appropriate specialties, both of which not only reviewed extensive records submitted by the plaintiff, but did physical examinations of her. Both unambiguously concluded she was not disabled as defined by the university's plan. They both prepared addenda when additional medical records were submitted by the plaintiff. They reviewed them and issued new reports, two additional reports by Dr. Blase and one additional report by Dr. Wilson.
Mr. Tuckle, was there ever a referral? And again, I'm going to ask Mr. June the same question regarding treaters. Was the claimant ever was her claim ever reviewed by a psychiatrist?
I don't know. I don't believe so, Your Honor. And she was not relying on a psychiatric disability.
Right.
There was a recommendation by at least by one of the IME doctors, that maybe she should get a psychiatric evaluation, but that was because he was concluding that she was not disabled under the medical conditions that fell under his specialty. It was not a recommendation that we have to consider her for a psychiatric disability, because she wasn't claiming a psychiatric disability.
Gotcha.
So it's important to know that plaintiff has never argued that the physicians who conducted the IMEs were not qualified. She's never argued that they were not in appropriate specialties to evaluate her condition. She's never argued that they did not perform appropriate medical examinations. And she's never argued that their conclusions were based on anything other than their best medical judgment. Um, there, really the issue that boils down to plaintiff's argument that the conclusions of the two IME physicians in their 5 different reports are wrong, and that the opinions of her doctors are correct. And respectfully, a disagreement among physicians is not sufficient under the arbitrary and capricious standard. to overturn the decision. And I'll cite some of the language from the Clements case. In that case, that's the Court of Appeals case. Long-term disability benefits were denied. The Court of Claims granted summary disposition to the university, and the Court of Appeals affirmed that grant of summary disposition. And in doing so, they stated, quote, "A plan administrator is free to rely on one doctor's opinion over another. When a plan administrator chooses to rely upon the medical opinion of one doctor over that of another in determining whether a claimant is entitled to benefits, the plan administrator's decision cannot be said to have been arbitrary and capricious because it would be possible to offer a reasoned explanation based on the evidence for the plan administrator's decision." And in the Clements case, there was just a single IME report finding that she was not disabled and multiple contrary opinions. But the Court of Appeals in that case found that even relying on just that single IME report in the face of the multiple contrary opinions was not arbitrary and capricious. Here, there are 5 separate reports by 2 different board-certified physicians in different specialties, all of which concluded that she was not disabled as defined by the university's plan. And it's important to remember what the university is not arguing. It's never argued, nor did the IME doctors suggest, that she has no medical issues at all. The question is simply whether she meets the demanding standard of complete and total disability, which is the complete inability to engage in any occupation for which she's reasonably suited by education, training, or experience. And the conclusions were she didn't meet that. And I would like to point out that in addition to those 5 IME reports, when plaintiff initially applied for Social Security disability benefits, she was denied those benefits as not being qualified. She asked for a reconsideration, was again denied at that level. And at both of those 2 levels, Social Security appointed physicians to review her application. And those 2 physicians both concluded at those levels of review that she was not qualified for benefits. So in total, there are at least 7 different reports by at least 4 different physicians, all concluding that she was not disabled as defined by the various plans. So I think there's simply no evidence that the denial was arbitrary and capricious. And by the way, if the arbitrary and capricious standard doesn't apply, in these cases, certainly by the time they get to litigation, there are always difference of opinions among the physicians. If there weren't, the case would never go to litigation. If everybody agreed that a claimant was disabled, then she would get benefits. And if everybody agreed she wasn't disabled, it likely would never go to litigation. So if the arbitrary and capricious standard doesn't apply, it would never be appropriate to grant summary disposition, and the court would always be in the position of having to make medical determinations as to whether or not plaintiff was actually disabled as defined by the plan. And I don't think it's reasonable to believe that that can be the appropriate standard. So for all those reasons, the failure to file a witness list and the fact that there's a plethora of evidence that the decision to deny benefits was not arbitrary and capricious, I argue that defendant is entitled to summary disposition.
Thank you very much. And you'll have a chance for rebuttal. So, Mr. June.
Yes. So I have a variety of things to talk about. First of all, the witness list issue. Now, Mr. Tuckle's been very gracious with me, and so I want to be clear that he has cooperated with the various extensions I needed and everything else. So I'm not trying to cast aspersions or anything. But 5 months ago, I sent Mr. Tuckle an email indicating that what I wanted to do was, because he had filed this motion, I wanted to wait, see if the motion was granted or not. If it was not granted, I would file a witness list confined to the people in the claim file so that there's no surprises, and offering him any discovery he needed to avoid any prejudice. So I really don't think there's a prejudicial issue.
But Mr. June, do you have agreement from the other side that that's how you're going to proceed?
No, I don't, which is why I didn't simply proceed. Okay, I don't have that. So basically, the case he has cited is a case that gets to the point of trial, where in trial, there still is no witness list filed. And the court there is very clear that the judge has discretion to do all kinds of things with witnesses. In this case, there's no doubt that he knows all the witnesses. They're all in the claim file. I haven't hidden anything. There are no surprises at all. And I'm offering, and if he can do this, he has never requested discovery regarding any witnesses. It's not like I've refused. So I really don't think there's an issue that amounts to the point of granting summary disposition. Perhaps some other, the court suggest that case he cites indicates there are all kinds of sanctions, but one tantamount to dismissal would be severe. And so given that that I've offered accommodation, I really don't think dismissal is warranted on that basis. And
But once he notified you, why not just file a witness list?
because I did, well, once he know, because I don't know the answer to that completely. Perhaps I could have. I thought I needed to file a motion to file a witness list after that. And
right. If it was late, you should, yeah.
Right. And so, and I would have to seek concurrence and not get concurrence and all of that stuff. And I felt that since I had already asked him and explained that I would do such a thing if summary disposition is not granted, I felt like the right thing to do was to wait to see if summary disposition is granted and then make a motion if it's appropriate.
Okay, well, you can go on to the merits now.
Okay.
Unless you had some other preliminary issue.
No.
Okay.
Mr. Tuckle suggested that if this was not the university, this would be an ERISA case. If this was an ERISA case with an insurance entity, then discretion would be banned. Okay, because Michigan has a ban on discretion that applies in ERISA. It's saved from ERISA preemption.
Well, where's that?
It's in a regulation. I believe I may have cited it in my
I don't recall seeing it.
brief. But we have a ban on discretionary clauses. The brief, I admit, was not my very best piece of work. Yeah. And so it's Michigan, it's cited in the brief, luckily, on page 9, Michigan Administrative Code Rules 500-2201 to 2202. And those
500, wait, say that again, please. 500.
500.2201 to 500.2202.
Okay, thank you.
Those rules ban discretionary clauses, and they've been upheld even in the context of ERISA, those bans. So, and that declares it's against the policy of state of Michigan. So if we were in the ERISA context, we would not be talking about discretion, not at least like that. So then another thing is that in a contract case, the only contract cases that Mr. Tuckle has identified involve the University of Michigan's plan. As far as I know, no other ones. And I don't think you can find a contract case, a general contract case that employs sole discretion or something like that, because that is illusory under Michigan law. When you say you have sole discretion, there's no mutuality of obligation. There is no.
Well, why is that impermissible so long as the party with discretion acts in good faith in exercising their discretion?
Because then basically, well, if that's what you want to put the standard as, perhaps something could be done, but that's not the way the law has gone. The way the law has gone is if it's up to me to decide whether your performance is satisfactory, then you don't have a right to enforce the contract. Okay, you have a right to beg me to see that you performed properly. That's all you really have. There's no contract because you can't enforce that if I simply say, this is not satisfactory. Um, and if you think about this in a different context, if this were not a government claim, we would be talking about a jury. How would a jury ever decide an arbitrary and capricious thing? It's not possible. They just decide preponderance of evidence. What's the preponderance of the evidence? Now, more importantly than I think anything else, the Giles case is the precedent, and the precedent is the statement that this is a contract case where the standard is proving by a preponderance of the evidence. Mr. Tuckle is looking at other cases that seek to modify that, or the dicta in Giles, but he's not looking at the holding. He's sort of disregarding the holding, and I don't think we can do that here. If he wants to modify the holding of Giles, we have to go up a step or two. I don't think that can be done here in a trial court. Giles controls.
Well, let's say we look at this simply as a common law contract case.
Yeah.
Is it your position that the discretion language is void?
Yes, and I cited that in my brief. That's the Earl Dubey case, D-U-B-E-Y, and that is cited.
Say that again one more time, Mr.
That's Earl, E-A-R-L, Dubey, D-U-B-E-Y, which basically recites that terms granting sole discretion are illusory and unenforceable, but this will not affect the enforceability of other portions of the contract that are valid.
I'm just flipping through your brief here, looking for that case so I can get a cite.
Yeah, it's on page 9 of the brief.
Page 9.
Middle of the page.
Earl Dubey and Sons. Okay, got it. Thank you.
And I don't think that you'll be able to find, I haven't been able to find a contract case in which discretion's been upheld. There is one exception, and that has to do with commissioned artwork type of things. I will pay you if you paint a portrait of me to my satisfaction. Okay? Those kinds of things can be enforced like that, but you don't get to keep the painting. And those cases go way back a century or two. So basically, we're having that. Now, even in Giles, in that footnote that Mr. Tuckle is mentioning, the court describes the argument as disingenuous and then goes on with the dicta. But, to say that the dicta is the rule is just not the way the law goes. The rule is what's in the ruling. And that means that we look at this case by a preponderance of the evidence. Another thing here, so as we go on, I deal a fair amount with ERISA cases. And when you're dealing with ERISA cases, we are dealing with fiduciaries. The reason you get discretion is because you're in the position of a fiduciary and you have fiduciary duties. This is not a fiduciary situation. This is not something where the university is a fiduciary with respect to this. And if they were, they would actually have a duty under ERISA to act solely for the benefit of the plan participants and beneficiaries, not for themselves. And then when they go and do this, so the ERISA regulations are voluminous. And the regulations regarding claims procedures are substantial. And if you don't follow them to the T, you do not get discretion, no matter what happens. it's just a long thing. But the other part of this is that we're conflating the idea of a review under ERISA with the idea of a contract dispute under Michigan law.
I
And
understand.
under ERISA, the review is a review of the entire record. You don't get to just review bits and pieces. And they don't get to rely on bits and pieces. They have to review the entire record, and they have to produce the entire, in federal court when we do these, we have to file the entire administrative record under seal. And that's not what's going on here.
But we're in agreement that yeah, sorry, I lost my train of thought. Continue.
That well, so we don't have any of the thinking that went on with the claim administrators. So their claim notes are not in here, their whatever are not in here. We don't have any of that. Okay. So you can't.
Well, I could understand.
Decision.
So your position is that the question of arbitrary and capricious requires discovery?
No.
Or
I think the question of arbitrary and capricious, there are fact disputes, but I think it's out of the question because it only applies in situations similar to a trust where there's a fiduciary. It's contingent on fiduciary duties and the exercise of fiduciary duties. So that's why I think the arbitrary and capricious standard applies. Now, that standard can apply in the context of certain discretionary rulings in courts, but it doesn't apply to a contract. You don't get to just say one side controls whether the other side performed.
So let me ask you the question I said I was going to ask you, which is if this is an arbitrary and capricious standard, do you see a question of fact?
Oh, yes. So first of all, they have not, I would argue that it's arbitrary and capricious in an ERISA case because they have not followed a proper process involving the whole record. But more importantly, they have not acknowledged things that are in the record like, well, good to hear. So
but more importantly, they have not acknowledged things that are in the record, like just in case you lost your train of thought there.
Okay. So at this point, they have to do that. But there are other things. For example, relying on record reviews is not arbitrary and capricious, absolutely arbitrary and capricious, but it leans that way when you're dealing with things that require clinical examination. In this case, we have diagnoses that require clinical examination. So the opinion of Dr. Wilson is suspect and arguably arbitrary, considering that he doesn't have anything to base that on except for the records. He says there's no objective evidence by disagreeing with the doctors who examined her. He did not examine. Was it Wilson or I forget which one?
Wilson was the second.
Yeah, okay. So but it's arbitrary and capricious to favor those doctors and not look at all the evidence. There's a lot of stuff that goes into the arbitrary and capricious analysis in federal court under ERISA, but it doesn't even apply unless we get to the point of saying we are dealing with a fiduciary of a trust-like fund. And I don't see that. It's not like we're, by the way, under Michigan law, if we're doing a review of a record, and this is cited in the brief too, I think, I hope, if we're doing it as, yes, it is. So if we're doing a review, if the university is a state agency, if a state agency is doing a review of a record, then the standard is not arbitrary and capricious per se, but whether the facts are supported by competent material and substantial evidence on the whole record. That's constitutionally required. So the review has to include, at a minimum, the determination of whether findings, rulings, orders are authorized by law too. So none of that's really argued here. We're not trying to argue it under that standard. And if we were, we would be firmly into the Administrative Procedures Act. The university doesn't get to have a quasi review. The Constitution requires that if that's what's happening, if it's a quasi judicial determination, then it has to be done under that. And there are implementing statutes and regulations regarding that. It's just, what we're trying to do here is import one little feature of ERISA without bringing in the whole thing. And we're trying to discard Michigan contract law. There's no basis for suggesting that, under MCR 2.116C10, the question is whether there's a genuine issue of fact. You don't get to say there's no genuine issue of fact because we don't think there is one, okay? And that's essentially what they're saying is we have discretion, you can't overrule us, you can't find a dispute of fact because we have discretion to decide there isn't one. No, that's not the way that court rule works either. So I think we're in a position of, if this were to be done in Michigan court, I think we would be more in line with equitable rulings. We would have to have a bench trial with all of this stuff, and then the court could decide whether there was some application of discretion in the administration of the fund. But in a contract case, I'm not aware of any contract case other than the argument for these University of Michigan ones that get there. So I just don't see any other, that's where I'm at. If you have any more questions, I'm happy to answer.
Do you see a difference between a standard based on arbitrary and capricious versus a standard based on good faith?
So every contract requires good faith, and we don't have a bad faith cause of action or a bad faith statute. Every contract requires good faith, but you would not be deciding you would be deciding whether they acted in good faith. They would not be deciding whether they acted in good faith. You would be deciding whether they acted in good faith.
But on a C10, the question is, what evidence have you presented of bad faith?
I don't think I have to. Well, I've presented facts supporting the findings, including facts from the university itself. And we could get into that, but I think Mr. Tuckle's wrong about that. Basically under MRE 801 D2A, and this is discussed on pages 7 to 8 of my brief a little bit, okay? A party's employee, the statement of a party's employee is admissible as a non-hearsay admission of the party if the statement was made by the employee while acting in the scope of the employment. So doctors making medical conclusions while in the employment of the university.
I'm listening, go ahead.
Those are admissions.
I'm just looking for my court rules.
As to those medical conditions. Okay.
I understand.
And so I believe that they're there. They have never, you want another example of arbitrary and capricious, they've never explained why their doctors, here we are, we have the University of Michigan with the best doctors in the world, and they want to say they're a bunch of runts, and here's somebody else who says they're completely wrong. And you should believe the other person instead of their own amazing doctors. So
Which U of M doctors are you relying on? I mean, I saw the
there are 2,700 pages. I didn't include the whole record, but there are.
Well, I got what you provided me with.
Yeah, I know. And at least there's at least. I'm going to see where I referred to. Hold on. So there's Dr. Syed Sorab. There is
the only U of M doctor I see here and what I have is Dr. Fortier.
There's Dr. Fortier.
I see. That's also a U of M. Okay. Now, are they employees of U of M?
Yes, Michigan Medicine.
And does the rule, I'm looking for my court rules, which I set down somewhere and I can't find it, but it doesn't require that the employer essentially grant authority for the employee to bind them to that admission?
No, I don't think it does. That's my reading of that case. On it, hold on, what case was that? My reading of that case, which is the Shields versus Redo, is that if your employee says something while acting in the scope of employment that you don't have to have, that takes care of the question of apparent authority. You don't have to have apparent authority when you're doing.
Shields v. Reynolds, you said?
Reddo, Reddo. It's 432 Michigan 761. And all I'm saying, I'm not saying they had the ability to bind the university regarding anything under the plan. But with regard to the conditions they diagnosed and the medical observations they made, I think those are admissions of the university.
Okay. We'll take a look. Very good. Anything else?
No, that's it.
All
right, then we're back to you, Mr. Tuckle.
Thank you, Your Honor. Not in any particular order. First of all, I think it's important to remember that the university did not make the decision as to eligibility. They have an independent third-party claim administrator. So when Mr. June was talking about fiduciaries making decisions under an ERISA plan, and you essentially can't do self-dealing, that's not what happened here, because the university engages an outside third-party administrator who actually makes the decision. The university is not part of that decision-making process. With regard to admissions, I think you're exactly right. There has to be authority to bind the employer for a statement to be a party admission. And at most, I think the argument here could be that there's an admission that that's what these doctors believe to be true, as opposed to there's an admission that that their opinions constitute fact as to whether plaintiff was disabled or had certain conditions that completely disabled her. We don't disagree that there are physicians' reports that plaintiff relies on that come to different conclusions than the medical reports on which the university is relying. Right. That's the nature of the dispute. But there's not an admission that because a university doctor said, I think plaintiff has X condition, that she actually has that condition and that can't be refuted. That would make no sense. And in terms of relying on university physicians, the people who participate in the university's long-term disability plans are university employees. Their insurance coverage almost always sends them to university doctors. If that were the standard, there could never be a dispute when a university doctor says, I think the person's disabled, because they almost always go to university doctors. That can't be the appropriate standard. And with regard to the records review, I cited the case saying even relying only on a record review, and even in the face of opinions from treating physicians, it's not arbitrary and capricious to rely on a record review. But these were not record reviews. I think Mr. June is just incorrect. Both of the IME physicians, Dr. Blase and Dr. Wilson, conducted physical examinations of
Yeah, that's what I thought.
and they also did extensive record reviews. And in fact, Dr. Wilson listed all the medical records he looked at, hundreds and hundreds of pages. And he indicated in his opinion why he was coming to the conclusion he did, in part based on his observations during the physical exam, the plaintiff's ability to get on and off the table without assistance, her ability to ambulate without needing to use a cane, her ability to walk to and get into the vehicle that drove her to the opinion. So this is not a case where we're saying our record review overrules your physical exams. It's our physical exams and record reviews and direct observations demonstrate that it's not arbitrary and capricious. And they cited why the actual objective lab results and X-rays and MRIs were not conclusive. Most of those were completely normal or essentially normal. So if the court applies the arbitrary and capricious standard, I don't think there's any dispute, or there can be any real dispute, that there's evidence that what the claim administrator did was arbitrary and capricious. With regard to Giles, I'm very familiar with Giles. That was my case. Giles said that we are applying a de novo review, and I don't dispute that that's what Giles said. But Giles didn't say in every case when making a review, it's a de novo review. They said in this case, it's a de novo review because the language that's being relied upon for discretion is insufficient to preserve discretion to the claim administrator. But if you do, then it's an arbitrary and capricious standard. And every case under the university's plan that came subsequent to Giles applied the arbitrary and capricious standard. In fact, the Proft case was a case that I had against Mr. June. He made these very same arguments, relied upon Giles. The court looked at all of that and rejected that argument. So it is true that I am primarily, not exclusively, but primarily citing cases under the university's plan because it seemed to me that the most important precedent to rely on are cases under the very same plan at issue here, relying on the very same discretionary language at issue here, all of which apply the arbitrary and capricious standard.
You said you were, what was the name of the case that you and Mr. June had together?
The Proft case, Proft.
Okay, got it. Okay. Thanks.
I'm somewhat confused about the argument that that the entire record should have been provided because it sounds like the argument is this is not an ERISA case and therefore the ERISA standard doesn't apply. But you should still have had to proceed as if it were an ERISA case, even though we all agree it wasn't an ERISA case. And we disagree about what the implications of it not being an ERISA case are. But clearly on a C-10 motion, there's no requirement that I provide everything, and plaintiff had the opportunity to provide whatever contrary evidence he wanted, and in fact did so. So I just don't think that argument is accurate. And I will point out that in the original decision the court issued granting summary disposition, which I understand the court it granted reconsideration subsequent to that, but the court certainly suggested that the arbitrary and capricious standard was the appropriate standard, saying that there's no relevant evidence as to whether the claim administrative decision was arbitrary and capricious. So that's at least a suggestion.
I understand, but just to be clear, I mean, I was applying the standard that you argued because there hadn't been a response. But I see your point.
Understood. And the court in that case also in that decision also said that all of the multiple medical records that defendants submitted support the administrator's determination. And that's still the case, even if the court isn't relying on the prior grant of summary disposition. It is still the case that everything we submitted supports the claim administrator's decision about it being arbitrary and not being arbitrary and capricious because they had substantial medical records to rely upon. I'm not sure if there's any other questions the court has, but I think Giles is simply inapplicable in this case, and that all of the other precedent applied the arbitrary and capricious standard appropriately. I think that's the appropriate standard to apply, and if that standard is applied, summary disposition, I think, is clearly appropriate.
Okay. Well, it's very interesting, gentlemen. I appreciate your arguments. As you know, I'm leaving in about 3 weeks. We'll certainly have an opinion to you before I'm gone. And then, depending on what we do, you can either take it up or deal with a new judge if I don't grant. Okay.
Thank you, and congratulations on the next episode.
Thank you very much, and I hope you're feeling well.
Thank you.
All right, Mr. Tuckle, thank you very much. All right, the matter is concluded then. Thank you.